Hello, this is R.J. Deacon, reading slip opinions from the United States Supreme Court. Today's reading will be Murphy v. Smith et al., certiorari to the United States Court of Appeals for the Seventh Circuit. Argued December 6, 2017. Decided February 21, 2018. Petitioner Charles Murphy was awarded a judgment in his federal civil rights suit against two of his prison guards, including an award of attorney's fees, pursuant to 42 U.S.C. 1997 E.D.2, which provides that, in such cases, a portion of the prisoner's judgment not to exceed 25% shall be applied to satisfy the amount of attorney's fees awarded against the defendant. The district court ordered Mr. Murphy to pay 10% of his judgment towards the fee award, leaving defendants responsible for the remainder. The Seventh Circuit reversed, holding that 1997 E.D.2 required the district court to exhaust 25% of the prisoner's judgment before demanding payment from the defendants. The Supreme Court held, in cases governed by 1997 E.D., district courts must apply as much of the judgment as necessary, up to 25%, to satisfy an award of attorney's fees. The specific statutory language supports the Seventh Circuit's interpretation. First, the mandatory phrase, shall be applied, suggests that the district court has some non-discretionary duty to perform. Second, the infinitival phrase, to satisfy the amount of attorney's fees awarded, specifies the purpose or aim of the preceding verb's non-discretionary duty. Third, to satisfy an obligation, especially a financial obligation, usually means to discharge the obligation in full. Together, these three clues suggest that a district court, 1, must act, 2, with the purpose of, 3, fully discharging the fee award. And the district court must use as much of the judgment as necessary to satisfy the fee award without exceeding the 25% cap. Contrary to Mr. Murphy's suggestion, the district court does not have wide discretion to pick any portion that does not exceed the 25% cap. The larger statutory scheme supports the Seventh Circuit's interpretation. The previously governing provision, 42 U.S.C. 1988b, granted district courts discretion to award fees in unambiguous terms. It is doubtful that Congress, had it wished to confer the same sort of discretion in 1997 E.D., would have bothered to write a new law for prisoner civil rights suits alone, omit all the words that afforded discretion in the old law, and then replace those old discretionary words with new mandatory ones. This conclusion is reinforced by 1997 E.D.'s surrounding provisions, which, like paragraph 2, also limit the district court's pre-existing discretion under 1998b. The discretion urged by Mr. Murphy is exactly the sort of unguided, freewheeling choice that this court has sought to expunge from practice under 1988. And his suggested cure for the rudderless discretion to have district courts apportion fees in proportion to the defendant's culpability has no basis in the statutory text or roots of the law. Judgment is affirmed. Justice Gorsuch delivered the opinion of the court, in which Justice Roberts, Kennedy, Thomas, and Alito joined. Justice Sotomayor filed a dissenting opinion, in which Justice Ginsburg, Breyer, and Kagan joined.